Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. It has come in the press, I think last week on Thursday, an inspector, that is Circle Inspector Dharavath Krishna of previously Kamareddy police station, he was convicted for assaulting an advocate. This is the news. It has come in Telangana press. Of course, somebody forwarded it to me. There are a couple of legal points involved in this affair. Therefore, I am making this video. An advocate by name Mr. Chintala Gopi of Kamareddy approached the Inspector of Police in a land dispute on 30th March 2013. He represented the client. He went to the police station, and normally, since it is a land dispute, police might have avoided to interfere, or sometimes police will overact in civil cases. Actually, I do not know in which side our advocate has gone, but whatever it is, an advocate is an advocate. The CI should have given due courtesy or respect, or the CI might have told him that, "Hey Baba, this is a civil case, we can't interfere." Or even though if he wants to interview, he can say, "This is the matter. If you want, please settle it in this line." So anyway, so there was a war of words between the CI and the advocate, and CI literally thrashed him. So the profession of advocate is a noble profession. So he was annoyed. He informed the same to Kamareddy Bar. And you know, Kamareddy Bar Association advocates, they have boycotted the court for 100 days. 100 days. So demanding action against the CI Krishna. But no action was taken. The police did not take any action. Ultimately, Chintala Gopi, the advocate, he filed a private complaint under section 200 crpc. Of course, normally, even though you file it, it will be endorsed to the same police under section 156 class 3 crpc also. This is the legal point. Please remember section 200 crpc. So, in this connection, I want to tell CRPC. Anyway, the case was filed. The magistrate has to take it on file. The trial was conducted. It has taken 6 years for the trial to be completed. Ultimately, on the last Thursday, that is 1 week back, the junior civil judge, that is second AMM, Kamareddy, she has convicted the accused and sentenced him, the CI, to undergo imprisonment for 6 months and fine of rupees 1,000. If he doesn't pay the fine, he has to undergo 1 month sentence also. Normally, since it is below 3 years, it will be suspended. He can go for appeal also. So, in this connection, the legal points. Number one, the relation should between the police and the advocates, though not cordial, must be courteous or retrospective. So, normally, we think in one line. So, since I worked as a police officer, up to that too retired as an additional SP, and now I am an advocate, so I can see both the sides. When we were sub-inspectors, we used to give much courtesy. Of course, legal profession was also considered to be a dignified profession at that particular point of time. The advocates, they did not come to the police station. But lastly, I have seen some advocates coming to the police station and asking for the FIRs, and incidentally, they became High Court judges. Of course, time will tell. Here the point is, if the police do not reach the case under 154, the provision is there that under 200 or 156 class 3, you can file a private case. So, if the private case, normally they endorse it to the police, but here, the judge definitely as an advocate, our friend might have requested the magistrate to take the charge sheet directly on file and conduct the trial. It should happen. Right. Second point, going to the police station, is it advisable or not? So, as advocates, you have to know Please remember Article 22, Clause 1 of the Constitution of India says an accused can be defended by an advocate of his choice. Even Section 303 CRPC also says yes, an advocate can be engaged by an accused person. But here, what is the purpose of you are taking him to you are taking the client to the police station? I don't know whether he is accused or not. If he is accused person, a lawyer is 100% correct. But if it is a complainant or if he is a witness, there is no necessity for the advocate to go to the police station and actually incur the displeasure or the wrath of the police officers. So police officer, you need not expect him as a Buddha. Definitely he will use the so-called language, no doubt. We feel bad when he is using the language. At the same time, we have to understand his difficulties also. So normally, as a police officer, normally they give respect. Very recently it happened. In one case, some people asked me to go to the DSP's office. I didn't go. The other side brought the advocate, of course, that young boy. So he went to the DSP's office and he asked my client, you know who I am, I will drag you to the court like that. He has threatened. This type of persons are also there. So to conclude, I want to tell you, definitely this is an eye opener to the police. They should be courteous to the advocates, because the police manual says whoever comes to the police station, he has to be treated with courtesy, if not respect. At least courtesy requires, whether he be an advocate, whether he be an ordinary complainant. Second point is, the lawyer can go to the police station or can go to the court under Article 22, Clause 1 of the Constitution of India to defend his counsel, that is accused. Even Section 303 or 304 also says regarding that legal aid only for the accused, not for the witness. These two legal points are necessary in this connection. So therefore, to enlighten you on the particular legal points, I am making this video. I do not say whether who is correct, whether the police officer is correct or whether the advocate is correct in this particular aspects, because every case depends on the facts and circumstances. It shows that Mr. Krishna has overacted on the advocate. We don't know whether Gopi, what type of person, we do not know. But whatever it is, these are the legal intricacies involved in such incidents. So better you know the law and proceed. Thank you very much.